Welcome back, everybody, to our study of the law of trusts. In this lesson, what we're going to do is talk about the concept of equity. This is going to be essentially the first three or four of these lessons on the subject of trusts. The first chapter of this major topic is, of course, looking at the idea of equity, looking at the historical development of equity, and then looking at some of the major maxims of equity. The aim here isn't for you to have a substantive, overarching understanding of equity in any particular great detail, but the aim is for you to understand equity to a good enough extent to then be able to transfer your understanding of equity to looking at equity's greatest invention, which is, of course, the nature of the trust. And then we'll start to talk about the trust in more detail, talk about the formation of the express trust, all the different kinds of formalities, constitution, etc., etc., etc. So, like I said, the previous lesson was an introduction to the subject of equity in trusts, talking about that subject in its general format. We noted that we're going to go through and spend a lot of our time in this series of lessons looking at the concept of the trust, because essentially this is a subject on law of trusts. This is a subject on trusts specifically, which is, of course, the most important invention out of equity. But is a way of getting some kind of foundational knowledge of equity in more detail. I'm going to spend time in this lesson, the next lesson, and the lesson after that talking about this particular concept. So we're going to ask the question more formally in this lesson: what actually is equity? Now, this is a question that we touched on briefly in the last lesson, and we examined in its general format in the last lesson. But we're going to go into a little bit more detail in this lesson, and then in the next few lessons we'll talk about how this concept began to emerge within the history of English law, talking about the development of and the rationale behind this idea of the Court of Chancery, the way in which the Court of Chancery would develop over time, the way in which the Court of Chancery in some cases would actually clash with the common law at instances. And there are notable examples during the early period of the Stuart dynasty where this happens. And then in the Victorian era, we see the fusion of law and equity with the Judicature Acts, the Supreme Court of Judicature, and the establishment of this merged system where you have both law and equity being adjudicated under the same jurisdiction. So the previous lesson, we had something of a definition of equity, noting that it was a concept which related to the idea of fairness, the idea of justice potentially, and so as a result of which we can have a basic understanding of what equity actually is. But it won't be until we've looked at these lessons in their entirety that we understand what actually equity is, because I can say equity is fairness, and equity relates to things pertaining to justice, for example, and we can talk about the theoretical approaches and the procedural approaches, which we will do in this lesson. But until we have an understanding of what equity actually involves and what equity has involved us understanding over the history of English law, we're not going to have the best definition or understanding, because we can essentially divide the subject of equity into two conceptualizations. We can talk about equity in the general by talking about the theoretical approach to equity. This includes examining things like the fundamental rationale and justifications for having the influence of equity within the common law. But there's also the legalistic approach, which is essentially how this applied to specific cases and the ways in which it would apply to specific cases. So when we look at the theoretical approach, we know, of course, that from the standpoint of theory, equity is a concept which does indeed relate to things pertaining to morality, to justice, and to fairness. According to Cohen, for example, the concept of equity is one which derives mainly out of the works and the ideas of the canon law, and the word itself, equity, comes out of the Latin equitas, the Roman law tradition, which was the sort of Latin conceptualization of justice, equality, symmetry, and fairness. So we see this transferal from the Roman law, civil law tradition of equitas into something of the religious canon law traditions, and then we see this develop into this concept of equity itself. It's a little bit messy how it all begins to amalgamate together and to form into into the concept that we know of today, and that's really more of a subject for a legal historian more than somebody who is studying the law of trusts. So we will not spend too much time doing that, looking for the origins of equity in either the canon law tradition or even within the Roman law tradition. When it comes to the legalistic approach to equity, the actual way in which it was applied within on a case by case basis, we can look at the application in the procedure of legal systems. We will say that equity was essentially a body of law that would develop out of the English Court of Chancery. The reason why it became a body of law, almost its own separate jurisdiction, was because we see a shift away from the employees of the Chancellor to the application of judges within the Court of Chancery, and this sort of imbued equity with a certain amount of legalism, which essentially bogs equity in the Court of Chancery down to the same kind of critiques that equity was supposed to solve when we talk about the rigid, harsh nature of the common law. While equity exists in both the civil and the common law jurisdictions, if you remember back to that previous slide, equity derives out of the Roman law, the concept of aequitas, but it also derives out of the canon law, both of which were heavily influential in European legal systems. So it makes sense to suggest that it comes out of not just the common law in England and Wales, but also it comes out of the civil law traditions over in the continent. Under the common law, however, even though it derives out of or exists within both civil and common law jurisdictions, in the common law, equity did remain a separate and distinct jurisdiction until the Judicature Acts of 1873 and 1875. Now, the aim for the Court of Chancery and the aim of having a separate jurisdiction was to essentially make attempts to overcome the perceived inefficiencies of the common law, where the common law would be applied in the correct and ordinary way, but it was seen that the strict application of the common law leads to an injustice or an unfairness, then equity is said to be able to step in. And this all derives out of the monarchical authority that the king had to step into legal disputes and to utilize his power as the divine right of kings to make things right, to make changes to the particular decision of a case, to alter in a perceived manner to make a situation more fair or more just, to be able to deliver justice, essentially, which is one of the main aims of the monarchy. And so out of this concept, we then go from the king essentially delegating that authority to his chancellor, and then the chancellor ultimately delegating that authority to his chancery, and establishing eventually under the reign of King Edward III a formal place where the Court of Chancery would preside. We'll get to that in the next lesson. But one very useful definition of equity, or at least a definition of how equity operates in relation to the common law, comes out of the Dudley case of 1705, where they say that now equity is no part of the law, but a moral virtue, which qualifies, moderates, and reforms the rigour, hardness, and edge of the law, and is a universal truth. Equity, therefore, does not destroy the law, nor create it, but assists it. This is a very nice definition, or at least a very nice description of what equity essentially does. It talks about it being something which it almost transcends legal values. It is something of a moral value, and what it does is it sees the law itself. It sees the decisions that have been handed down through the common law, sees the way the common law is quite harsh. It is quite rigid. It has got something of a sharp edge to it, if you will. And what it does is assist the common law in being able to deliver justice in the most appropriate way. It does not destroy the law, nor does it create the law, but instead it assists the law. So the issue, what we find ultimately with the development of equity and the Court of Chancery, is that as it begins to develop, it begins to essentially take on a role of its own as a distinct body of law and legal rules. So whereas equity was seen as a very flexible, almost precise tool for the application of rules to specific cases. One of the things that we're going to talk about in the next lesson and the lesson after that is this idea that equity acts in persona, one of the major maxims of equity, the idea that it is essentially applied to the personal characteristics of a particular case. And so as a result of which, that made it very flexible and very applicable to various different circumstances. But as it begins to develop into its own distinct body of law and legal rules, partially because of the influence of judges being part of the Court of Chancery, or beginning to be part of the Court of Chancery, you could argue that the Court of Chancery began to become impeded just in the same way that the common law was impeded, with quite strict adherence to legal principles. And it wouldn't be until we see the Supreme Court of Judicature that we see something of a fusion between these two rules. Now, there is still debate about whether or not fusion has actually happened, and this is something that we're not going to get into in this series of lessons, but the quote-unquote fusion debate around whether or not law and equity have actually officially fused together, or that they still remain distinct despite having the same jurisdictional, the same area of jurisdiction, is a debate that will continue to take place.